So it's on that simple basis that we've sought two declarations from the court. One as to the unconstitutionality of the SI, and two, more specifically, that the exercise of the power to pass the regulations by the Governor General was outside the scope of authority conferred by the Public Safety Act.
Sir, the issue of time, it will only be valid for about 2 more weeks, little
Yes.
more than 2 weeks. Constitutional motions aren't usually heard that expeditiously.
Yes, that is a practical consideration and one that we bear firmly in mind. The consequence of it is that it is very likely, in fact, near certainty, that by the time the claim comes on for hearing, the law would effectively have been spent in that the 30-day period for which the restriction is to last would have expired. What that means is that the consideration of the legality of it then becomes somewhat academic, in that the court is being asked to consider the legality of a law that's no longer in force. Well, in practical terms.
Do you think that perhaps maybe the determination of the court will act as a deterrent to the government to not pass such a law in the future?
Yeah, well, the fact that the issue becomes academic is a hurdle that will have to be surmounted in order to get a hearing on the merits of the claim. Again, it's a significant hurdle, one that we're aware of. But the reason why the claim is being pursued nonetheless is we don't think, well, first of all, we think that the law is motivated really by political considerations. And we don't think that resort should be had to methods that curtail fundamental rights so readily, the fundamental rights of Belizeans, in the pursuit of political objectives.